Next step we're going to talk about is when is an I love you will not appropriate. So I'm going to give you some examples. At ELG Estate Planning, we do Medicaid asset preservation strategies. What does that mean? What that means is that we help make sure that a couple won't go broke, that if they qualify for the state to pay for their long-term care benefits, that they will use those benefits and the state will pay for the care. So what does that all have to do with an I love you will? Let me give you the best example that I have. So let's say you are a married couple and you have a couple of kids and they're not minors, they're adult kids. And let's say you don't have over $2 million. And let's say you don't have long-term care insurance. That is a very common scenario where when we meet with a couple, even if they don't have health problems now, they know that the number one threat to their financial security is long-term care costs. At $10,000 a month, it does not take long for money to run out. So a couple like I just described, and I love you will might not be the right kind of will. But let me explain how we can put together an asset protection will with the simplicity of an I love you will. So in our scenario, let's say we're meeting with a couple, they're 50 years old, and they're still working. They're not retired, they're in good health, they don't have long-term care insurance, and they've got $2 million. We are not, and they're not accruing a lot of money. If they're accruing a lot of money, I'm concerned about taxes, but let's say they're not accruing a lot of money. The type of a will that might work best for them is a will that says, on the death of the first spouse, everything goes to the surviving spouse outright without any protections. But the will include something that's called a contingent asset protection trust. Why is it contingent? It's contingent because we don't know what may happen in the future. And let's say at the time of the first spouse's death, that second spouse actually needs care. Let's say the first spouse died because it was a car accident involving both of them, and one was killed and the other wasn't killed, but she was left no longer independent. Let's say, heaven forbid, she's paraplegic and she can't work and she's going to need care. Well, even though we set it up to say, on my death, everything goes to my spouse. Remember I said we put in our will a contingency for asset protection, that asset protection trust. So what will happen is, number one, there will be a probate. Why? Because that is the only way we can fund this asset protection trust for the surviving spouse. And she needs asset protection because she needs care. We didn't know she was going to need care. When they met with us, when we did the plan, they were both healthy. There was no indication that she was going to need care. And that's why we set up their estate plan with an apparent, hey, everything's going to go out right to my spouse. But just in case, we put this trust in the will. And because that just in case happened, then through the probate, the deceased spouse's one half of the estate, let's say it's $1 million, if it was a $2 million estate, is going to fund this trust for the surviving spouse. What does that mean? I said there was going to be a probate. There was going to be a probate. Let's say, worst case scenario, that probate costs $10,000 to do. We're protecting $1 million for that surviving spouse so that when she actually needs Medicaid, which she might need right away, that she can have $1 million in trust and Medicaid will still pay for her care. So we combine the concept of the simplicity of an I love you will, but we do it a little bit differently because we put into that trust the opportunity to protect assets through this contingent asset protection trust. That's the value of having an estate planning lawyer who understands Medicaid and understands the way to protect assets, because without that, If it was just an I love you will with no asset protection trust in it, under that scenario of the car accident, that surviving spouse would have to spend down all of her money before Medicaid would pay for her care. Whereas because we did the plan we did, she has $1 million in trust, and yet Medicaid will pay for her care.